What's the lady?
Oh, Melissa?
Melissa, yeah.
Yeah, she was going to another class.
You'll be able to get them at lunch.
Okay.
Okay, no problem. And we still got people that hadn't picked them up. They bought them yesterday, so I guess if anybody's busy, we got them.
Okay. I'll take them.
Oh, there you go.
Thank you very much.
Yep, you can have it.
Really?
Yeah, somebody gave me a whole bunch of the packet about it at Walmart or something like that, so. You can have it, it's all yours. Don't say you never gave it.
I will remember this.
Oh, I think my headache is starting to set in from last night. A little too much drinking, a little too much mixing.
Were you at the retreat lady?
Yeah,
Yeah?
yeah, and then I had, I switched to margaritas in the evening, so I had a lot of beer, some wine. Yeah, it was just so nice.
I've heard that's a good way to go, mix it up.
They've got it recording now. Do you want me to just pause it until we start?
Yeah, maybe a good idea.
It makes me sense, you're seating, I'm sure.
You can turn off the. Let's have the most interactive thing we can have here. The more you want to interrupt me, you can't bother me that way. I want your questions. I want you to tell me if you don't agree, if you got a problem with what I'm saying, if I'm not making it clear, all of that. Now, here's the other problem, is for these sessions, one, these handouts that I have to accompany this aren't on that CD. Okay. Number two, we don't want to print them up here. Now maybe what will happen, I talked to Rosie about it, is I'll email them to her. She'll print them off and put them out and make them available. But the bottom line is, you're going to get a faculty list. When you get that faculty list, you'll have my email address. Send me an email, and I'll send it to you electronically, okay? And that's for any of the handouts that you want. Just indicate which ones you want. Some of you, I know I've had in groups, and some of it will be, by nature, repetitive, okay? But it won't all be repetitive, because obviously this is much bigger than this one. But I can't start off this whole thing without talking for a few minutes about theory and themes and the storytelling methodology of litigation. You've heard it from a lot of different people. You've had different groups. You've had different plenary sessions. I want to try to put it in context for you. The first thing I want to tell you, and we will get into the specifics of this what here, don't get me wrong, this is just the intro, but you can't understand it without this. Think about it for a minute. The only way you can communicate is through stories. When you talk to anybody, you talk to a friend, you're telling some form of a story. Now, sometimes we tell better stories, right? You want to go out to dinner, you're talking to somebody, you may tell them the story of what a stressful day you've had. You may tell them a story about how hungry you are. You may tell them a story about something in the past that deals with the last time you went to that restaurant. Everything we do, even in science, it's all stories. You read about formulas, you read about things like that, before they're reduced to scientific formulas, they have been talked about in the form of stories. A great example is evolution, Charles Darwin. It was a storyboard for him, right? The story of this progression of evolution before he ever figured it out. It's just the way we are. We forget that. We think we communicate some kind of abstract system. So the first thing you have to realize what a trial is communication by a story. And when I talk about the storytelling methodology of litigation, what I'm saying to you basically is everything you do in this trial with the evidence, whether it comes in through the prosecution, comes in through the defense, are the characters for your story that you're stuck with, right? So this thing is so big, when you're trying to figure out what story you're going to tell, it's like this big. The only thing you can do, I think, is come up with a theory that makes this manageable for you, okay? Now, I used to come to programs like this as faculty and listen to lectures, and I hear people talk about theory, and I hear them talk about theme, and what would it be? It would be, somebody would use theme the same way somebody else was using theory, and it was always some abstract thing, and it's like, well, yeah, but how do I make this work? How does this really fit into my trial prep? How does it fit into putting the case together? So what I'm going to tell you is, okay, that's really not the handout, sorry. That's the stuff for my ethics presentation for me. Okay, what is a theory for me? What is the practical thing that it is? It's basically, probably if I do it better, if I just give you how I written it out, but I could break it down either way. It's a paragraph of 1 to 3 sentences. Now, that is not controlling. You might have to write 5 sentences in that paragraph. But you want to try to get it small enough to fit on one sheet of paper, right? It's a paragraph of 1 to 3 sentences which summarizes, and this is the important thing, 3 elements. They're so simple, and you know this stuff, but you probably have never broken it down and thought about it this way. 1, facts. This is the one that usually gets forgotten by us as litigators, and it's really important. 2, emotions. And 3, the legal basis for the citizen accused acquittal or conviction on a lesser charge while telling the defense story of innocence or reduced culpability. But the key thing is, it's going to be something tangible that's in your trial notebook, and it's got to be different for every case. You heard people talk about a theory can't just be self-defense. Why is that? Because that's only a part of it, right? That's probably the legal component. And when I talk about it being a legal component, I'm not really talking about legalese. I'm talking about the common sense theory, a common sense basis behind an instruction that you get. If you get a self-defense instruction, it might be called self-protection in your jurisdiction. People who don't know the law know from their common sense experience if somebody's attacking them, they have the right to defend themselves, and they're not doing something wrong. They know that if somebody's going to come after their child or their loved one, you're going to stand up and fight for them, right? And there's nothing wrong with that. That's not immoral. That's necessary, right? And that's all the law does. It codifies that, right? So that's what we're talking about in that regard. Now, I apologize to people who have heard this before. Can I read you just one so you get an idea of what I'm talking about? Outraged and angered by the dramatic bruises that appeared on the face, head, and body of 2-year-old Mary Smith, shortly after she was picked up from the home of Joey and Karen Burden, her babysitters that day, Mary's parents, the police, and even the examining doctor all assumed an assault rather than an accident, a crime rather than a fall, and that Joey Burden had hit and hurt that child. With little or no investigation and evidence, the police ignored and discounted the obvious explanation for the spectacular bruises on the fair-complexioned little girl. A face-forward fall on the wooden front steps of the Burden's home, which produced no wounds, no bumps, and no bruising. At the time, Joey and Karen comforted and inspected Mary and assured themselves that she was okay. Now that's a little story, isn't it? But it's also telling you a legal defense in there. Did you get it? Accident, right? And maybe in your jurisdiction you can have an instruction as an affirmative defense of accident. But if you don't, everyone knows that if it was an accident, that's reasonable doubt that it was a crime, right? And you don't have to call it reasonable doubt. So the reason and I could give you other examples, but we'll probably work off of this one for part of the voir dire, okay? That's why I wanted you to hear it. In the handout on storytelling, and even in the advanced cross-examination one, I've got this stuff packaged with other examples of theories, okay? But do you get what I'm talking about? Now, here's what's important in this theory. This is what's important. I believe this is the only way that you can try any case. I tell civil lawyers, I do some civil work. This is the same way for civil. It's the same way for an administrative hearing. Anything you're going to litigate, even if you were going to mediate, you need to do this. And I want you to understand something with regard to this theory. Once you have wed yourself to the theory, you've got the facts to back it up. It deals with all the facts beyond change. Unlike the old-fashioned approach to criminal defense work, you flaunt it. You don't hide the ball. You are showing it from the get-go. If you've got this, your power to negotiate comes from this. Your motion practice comes from this. When you are actually litigating in trial, the fact that you have saturated the judge and the prosecutor with your theory, when you go up and object, you're going to do the most persuasive thing you can say is, Judge, not only is your ruling wrong, but you know my theory is blah, 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 right? And what you've done has dramatically prejudiced what we're trying to do. It's impacted on us. And what appellate courts do, when they look at errors, what do they always say? Well, it was harmless because there's no prejudice. And if there's no theory of the case, they're looking at it as just, oh, well, so you didn't get this piece of evidence in, that's not a big deal on the whole picture. But when they can look at, but wait, this was a key part of the theory, and without this, the fact that you didn't get that in made it impossible to really persuade in that situation. So this becomes really important to you. And you know what else it does? It guides how you practice the case. It tells you, wait, I got a great motion to suppress. And actually, well, I don't want to waste time on that. I could give you an example, factually, but let me just say it like this, quickly. You're going to make a motion to suppress. You've got a really good basis to do it. You can win or have it as a golden parachute for appeal, right? But you can win this. But you stop and you think, if I knock this evidence out, even though they got this illegally, this moves my theory of the case, right? So what do I want to do? Do I want to win a legal argument and feel good that I show the judge and the prosecutor that I understand the law, but I'm taking something away from my case and moving the theory of the case? That's just stupid, isn't it? And see, that's why all this week and next week, this program breaks everything down for you, right? But you've got to see it as an integrated whole. And that's what the theory helps you to do. Every decision you make. You can't figure out how to cross-examine a witness unless you have a theory of your case and know how you're going to make that witness fit in and move your theory of the case. Why am I telling you all this? Because we can't talk. My way of doing voir dire, there is not one question that I'm going to tell you that you could use in every case. When Sunwolf talked, she told you about things that voir dires that you could do in every case. Now the reason I don't like that is because even when I get a tremendous amount of time for voir dire, I don't waste my time anymore on things that I could do from case to case. The theory of the case lets you prioritize what's the most important things that you have to get over that move your theory of the case. And I'll show you that when we start talking about the specifics. So that's why you got to have this theory, and that's why there will be no questions when we talk about here that aren't tailor-made, right, to that particular theory of the case. But, just one second and then I'll get you. But here's the important thing. I'm going to teach you, I hope, I'm going to try to teach you a methodology. The methodology, the rules, and how to put it together apply to every case. It's just that you have to put the specific analysis from your theory of the case into it. So you walk out of here armed with an approach, methodology to implement this. Does that make sense? Arthur?
I have a question. I've had a situation where the statement that the defendant made, I filed most of the suppress, but I really wanted his statement to come in, but I felt compelled to file most of the suppress. Because if I didn't, I felt like I may legally be attacked and say I didn't do my job. Even though I wanted to come in, a cop took a statement from my client saying it fitted with my theory of
Right.
being innocent, but I still felt compelled to file a motion regardless.
What you need to do to feel right about this, number one, and I know it's hard with some of your clients, you need to sit down and talk to your client and explain, we can do this and try to keep this out.
Right.
But you know what we're going to be doing? We're going to be helping the prosecution. We want to help ourselves. And you might even write a little letter out or a memo and have them sign it.
Oh, okay.
I do a lot, I did, well, I'm actually still doing it. People hire me still to do this. But I did a lot of death penalty post-conviction work, all right, where I had to go back and look at ineffectiveness of attorneys.
Right, yeah, that's what I'm
I apologize for some that were in my group that heard me say this at one time or another. Here's the thing about ineffective assistance of counsel or even a disciplinary proceeding against you, right?
Right.
It's almost impossible to show that somebody was incompetent for the choice they made. It's not the choice. It's did you know all the options? How many of the options did you know? And Arthur, you just told us that you knew that you had law on your side.
Right.
You knew that you had a good chance of either getting it suppressed by the trial judge, or if not, that if your man was convicted, you could win it probably on appeal.
Right.
But you also knew it helped your case.
Right.
So if you set that out in the letter and explain it to your client, I don't think it's the client's choice. I'm not saying that. I think that's still your choice. But
Okay.
you always get input from the client, unless they say, I'll leave it to you, right?
Right.
And they usually will do that.
Right.
But do you see what I'm saying?
Okay.
You have now done the right thing. You've done it in the right way. If anybody tries to complain at you, your client later, or a disciplinary action or something like that, boom, you've got the right answer. And I don't think anybody can fault you there. It's almost impossible to take away from the art of lawyering, and that's the choice. And it's hard to second guess a choice. It's real easy to see. And we have this happen when we're doing a cross-examination of a defense attorney, you know, an ineffective assistance of counsel hearing, and you ask them, you know, tell us what different things could you do here? They don't know the law. They don't know the factual options because they didn't investigate. That's where you win, see? And it's very hard to win it, but I'm telling you, that's the formula. Does that help?
Right.
Okay. So, the last thing I want to say is the way this also works is, and I hope you'll keep this in mind, at least think about it. The opening statement should never be like a closing argument. The opening statement is the chance you get to tell the story that you're trying to tell through the whole trial as a story, all right? And so when you see somebody get up, and I had a long talk with one of the people who gave the demo the other day, and I said, you were one of the best speakers I've ever heard. You are wonderful. You have everything, and when you were telling the story in there, I thought it was great. But when you started editorializing, you moved from what I think an opening statement is to a closing argument. And the jury's not ready for it. And you know what? It is not persuasive because they're not ready for it. But when you make your same points in the context of telling a story, that's when an opening statement under the storytelling methodology, methodology of litigation is. So what do we got? We got this one-page paragraph, right? That's the story as a theory. You've got the opening statement. The first time you can pretty much show the jury as a story what's coming. Then you put it all out there through cross-examination and direct examination, physical evidence. And then, at the end, in closing argument, what do? You do make argument there. You do point things out to the jury. You express an opinion, maybe not as it's your personal opinion, right? But that's what you do. But you still go back and tell excerpts of the story to support your argument, right? And that's how it all puts together as a storytelling methodology of litigation. So why do you came in here to learn about voir dire, right? And I haven't even talked about voir dire, but I wanted to get you to this big picture because now, say, what are we going to do in voir dire? So, just for a minute, will you all tell me what you want to, in the abstract? You don't have to do on a specific case. Well, a few times I'm going to let you say this, right? Do it this way. What kind of things do you want to accomplish in voir dire? Yes.
Yeah, indoctrinate the jury, like start getting them in the mindset.
Okay,
Like
so
you
you
can
wanna-
be careful and have an accident, right?
Okay, you want to indoctrinate them. Okay. Now, you know what? That's wrong. I have no problem. I agree with you. Never, ever, in talking to, in making a motion for expanded voir dire, right? Talking to a judge, or the reason I don't write about what I'm going to tell you in this voir dire, except in handouts that I hope stay in the hands of criminal defense attorneys, is when judges hear that, they'll say, that's not a legitimate purpose of voir dire. We know it is. It really is, but they don't want to look at it that way, right? So that's one. What else you want to do in voir dire?
Have rapport with the jury.
Have a rapport with the jury. Okay, that's two. What else? You want to find out a little bit about the jurors, maybe?
Right.
Okay. You're going to have to make some peremptory challenges, right?
Right.
And so, what is going to be the best way for you to find out the most reliable information about them that has anything to do with your case, right? Any other things you want to do in voir dire? I mean, that you want to accomplish?
Lay out your theory of the case.
Lay out the theory of the
Try to
case?
tell them what, try to tell them what you agree.
Okay. Anything else?
Look for cause challenges. I mean, you want to get
For
rid of
cause challenges, right. All right. Now, I'm going to tell you what I decided along when I came up with this approach. Is I decided the most important thing I want to do is what you said and what somebody said about theory of the case. But I want to do it in a subtle way. I do not want to talk to them about the facts of my case directly. Isn't that funny? How am I going to be able to do this? And I want to indoctrinate them in a way that people don't realize that they're being indoctrinated and that the prosecutor can't complain about and the judge can't complain about. Well, they'll probably find a way to complain, but they won't have a good basis for it, right? So the first thing for me is, and I have to say this to you, and I sometimes forget to say this when I'm talking about the whole theory of the storytelling methodology of litigation. You get all kinds of cases as a public defender or a criminal defense attorney in private practice. You get some where the jurors that you pick are looking at like a drug transaction, and the way these people live, they have nothing in common with them, right? And they think it's like a bizarre world. And you might have something that's not even that much. You may have a fight that comes out of some 19-year-olds, right? And it's over something that, some jewelry and that. So you got young people on the jury that understand this. But you got old people on the jury that are like, well, that was not the way it was in my day, right? But what you have to do when you come up with your theory of the case, not only do you have to deal with the facts beyond change, but you got to come up with a story that has a universal appeal. And so that's what the first thing you have to realize. You have to be able to communicate when you're indoctrinating the people the idea, the basic, common human experience that's tied up in your story. And I always use this example. There's a whole lot of other ones, but I think this was one easy for us to see. Most people know Romeo and Juliet, right? You know Shakespeare wrote it, and you know it was what it was about, and you know it was set in Italy, back in the time when people carried swords around, and they wore funny clothes and everything like that. And lo and behold, was in the late 50s, early 60s, they took that story and they moved it to the slums, the ghetto, well, the slums is a better word, of New York City. And they took one family and made them one gang, right? The Sharks. They took the other family from Shakespeare and made them the Jets. But the story remained absolutely the same. And the thing about it is, it has universal appeal, whether it's set then, whether it's set in Italy, when it's set in New York, whether it's young people who are using switchblades or swords. It doesn't make any difference. And they keep making Romeo and Juliet over and over again because people understand two kids young people falling in love, their families being against it, and tragedy coming out of it, right? That's the kind of thing you have to think about when you're putting your case together. How can I reduce it in my mind, this theory that I'm coming up with from these facts that deal with all the facts beyond change, but it's got to be something I can communicate like you want to do, right? Orient that jury, and you do it first and foremost through voir dire. Now, it's been a big buildup, right? So, here's the first thing. I'm going to take you through the steps of the methodology for this voir dire before, and you're really not going to see how it works until you get to the third or fourth step. But let's start off with the first thing. If you don't like anything about what I'm telling you, when you're all finished, this is a really important thing that you need to know. In voir dire, if you say to a potential juror, could you tell me, do you have, do you know, what are you doing? You are giving the juror, or the veneer person is what they are at that point, really, right? You're giving them permission to say, no, I don't know. Watch when people do voir dire. You'll see a lot of people will ask the questions that way, as if maybe you know, maybe you don't know. I learned this a long time ago, picking a jury in a death penalty case when the death penalty wasn't real, but we thought it was. And I had a jury consultant that I was training. He went on to make he and his partner went on to make a whole lot of money. They're psych teachers at the University of Kentucky in Lexington. But he leaned over to me during an individual sequestered voir dire, and he said, and I was asking questions about pretrial publicity, not in the method I'm going to teach you, but I was asking questions about pretrial publicity, and everybody was saying, I really don't remember anything. He said, tell them in a way, use the imperative. That's the secret to getting people to answer you in these kind of situations. You remember what an imperative is from grammar? Imperative is another word for a command. Now, obviously, you don't want to do it like you're Adolf Hitler or you're General Patton, but look at the difference. Tell us, blah, blah, blah. See? Share with us, blah, blah, blah. See the difference? You are assuming in the question that that the person has something they have to tell you. Most important thing, any kind of voir dire you're going to do, you're going to do that. Now, that makes you step back and say this. The first kind of voir dire we had was what? It was lecturing at people. And you know what? I was really good at it. The only trouble is, it was not a good thing to be good at. I can remember being asked to go up to places like the Indiana Public Defender Council, go up to Indianapolis, and I got up and trained people on how to be, it was like, it's like almost being a preacher, right? And probably some of you have still done this, right? Where you stand up and say, and do all of you understand the presumption of innocence? Would you agree with me that the presumption of innocence means that my client is cloaked in innocence? Somehow you believe that through osmosis, in the short period of time that you're talking to them, you are going to be able to change their mind and inflict this new idea on them. Doesn't work. Then the second thing, and I don't mean to denigrate this in any way. I knew Kathy Bennett. She's a wonderful person. And I wouldn't be where I am on how I think voir dire works if she hadn't helped us make this really big step. The really big step was, don't do it this way. Now we're going to do what some will have called the journalism questions, and that's what I call touchy-feely voir dire. And it was a whole lot better. But what it was about was to say to people, just look at it, how do you feel about race relations? Why do you feel that way, okay? Well, I got good at that, and I used it, but it dawned on me, how can I trust the answers? Here's a bunch of people sitting among, sometimes people they know, sometimes total strangers. There's a judge with a black robe on, right? And there's this elected or representative of an elected official sitting over there, and they're going to be honest. They're going to give aspirational answers. They may be aspirational in the sense that, I wonder what they want me to say. I guess this is what I should say. Boom. Or they're going to give the internal aspirational answer. which is what? Who I'd like to be, not who I am, right? So there's no way to gauge that. I don't think. And I think, Sunwolf told you, which was good, was give us an example, and then she created a hypothetical. But what bothered me about that, I don't mean to knock any of the faculty, I'm just telling you where I got my analysis, and you all were sharing, we all were there for Sunwolf's lecture, so I'm saying, what if that, when whoever did it, was it Kathy Bennett that did it, the example, I can't remember, but you know the example I'm talking about the family, that they took in, what if they would have been white? That's a hypothetical question, right? And that person could have just as easily said, we would have taken care of them too, The thing is, it's not rooted in anything. That was closer to being rooted into something because it was out of a true life adventure of a person. But you did a hypothetical. So when I got ready to move from this, from the touchy-feely to the behavioral description block here, I was thinking about going to hypotheticals. And I thought, that's so much better. So I'll come up with situations that are hypothetical, that are sort of like reasonable doubt and things like that people encounter. But then I thought, well, I'm making the same mistake. How will there be any check on this if you're doing it with hypotheticals? So, I say all that to tell you, I'm getting ahead of myself, but we're talking about the imperative, difference between share with us and how, what, why, where, when, all of that. The second thing I want to tell you is when you do this form that I'm talking about, you always use a superlative. Do you remember what a superlative is, first grammar? Okay.
No, I don't.
The worst, remember?
Yeah.
Comparative is better,
Right.
more.
And
A
most.
superlative is worst, least, any word with an EST on it,
Right.
right?
Right.
Okay, and why would we do that? Now, I didn't think this up. I came up with this idea that I'm telling you about voir dire on my own. But then I found that there was this whole science that was taking place in industry where they were changing interviewing. And they were moving from the kind of old-fashioned interviews, which really were aspirational. Where they would say to you, Heather, if you get this job and you become the public defender of OEFA, well, that's not easy. What will you do? And people could say, well, then people could give their ideas, right? And that might be nice. But there was no way to know whether or not they could implement them based on what they were saying, right? And they were losing money. They were taking people on the basis of those kind of answers and their resumes, and then these people weren't working out. So industry wanted to know how to make this work. And it's funny, it coalesced with what I was working on. And so the second thing about the superlatives is, they do this in behavior description interviewing. And why do they do it? Because all the psychological studies show, if you say, tell me the worst job you've ever done, you may not get the absolute worst that the person did. You might not get the second one, but you're going to get one of the top three. You are not going to get way down here where they did a mediocre job, right? So you use the superlative to be able to rank and to extract something as close as you can get to what you're looking for. Does that make sense? You don't? Go ahead.
Like, I picked maybe 20 juries.
Okay.
A couple of death penalty cases. I picked juries that, well, health cases. I guess I shouldn't take all the credit for it. But I've used the same approach you was telling me. I was telling, like, tell me something about this or subject.
And I said, what he just said, I say a lot, tell me, but it's really good to try to slap your face and try to say, tell us, so it's not just personal. You go ahead.
Okay. Yeah,
Tell me what?
I always, I may ask about race relations. Tell me what you think about race relations.
Mm-hmm.
Or tell me what you think when you see a young black male walking down the street. You're walking down the street, you see two young black males walking towards you. How do you feel?
Okay.
And so.
Now, and so your question is?
So I'm saying, how do I mean, that's what you tell me. How do I use a superlative under those circumstances?
I think that's a great thing you brought up. I was gonna get to it later, but I'm not gonna
Oh,
evade.
okay.
No, I'm not gonna evade, I'm gonna use that example right now. What Arthur is saying is, you might say, how do you feel about race relations? That was the first thing he said. That would be the Kathy Bennett touchy-feely way, right? I'm not sure I can trust the answer.
Right.
I might have the biggest bigot in the world saying, I think all people are created equal,
Yeah,
right?
I'm here.
And I deal with everybody the same way. Or we could do what Arthur said the second time, which was what? It was kind of a hypothetical. If you were walking down the street, maybe the person's been in that situation before, where a person of a different race is coming toward them and they felt funny about it, maybe they never have, but you're asking it in a way that's a hypothetical, so they could just kind of step out of who they are, in my opinion, and answer that question again. The way that they think might make them look the best, might be acceptable in this group, all of that, right?
Right.
So what question am I going to ask? And that's why I say I'm getting ahead, but my question would be, tell me the most significant relationship. Say I'm talking to a white juror.
Right.
Tell me the most significant relationship you've ever had with a person, with an African American. Okay? Now what am I doing? I'm making them go back and anchor them in their past situation. Maybe they've never had one, right?
Okay.
And now Arthur is thinking right now, well, Vince, you might not get anything there.
Right.
What's the first thing I get? The first thing I got is this person can't tell me any relationship at all that they've ever had with somebody of another race. Does that mean they're a bigot? No. But you know what? It means it's going to be harder. They probably aren't going to have a lot of empathy with the situation we're dealing here if race is a factor in this death penalty case, right? Now, they might be still a good juror, but,
Right.
I'm not going to get 4 hours with them. So, first of all, I can evaluate on the basis of the context. And, you write. Now, it doesn't end with just that answer. And I want to get to that, but I'll say to you, after you get them into the past situation, that's when you use the journalism questions to go toward your theory, or the issue as it's important to your theory. Who, what, where, why, how, right?
Okay.
That's how you're going to get into that story. Now, why is it so important to get into that story? Well, that's what we're going to get to next.
Oh, okay.
So have we got 2 things so far, right? We got an imperative, we got a superlative.
Right.
The next thing you have to do, and this is the hardest part, but it's not that hard. You'll see. But it is the hardest part, because so far it's been formula, right?
Right.
What we are looking for is the most perfect analog or analogy to what we want to discuss with them. The most perfect analogy. We'll probably never get a perfect analogy, right?
Right.
Just probably not going to. But how close can we get? Is it that bad? Is it that boring? She's yawning.
I was up that late.
No, I'm just And seriously, if there's anybody in here who's thinking this is not what you want to hear, you can leave. You're not going to hurt my feelings, right? Okay. So what is this? What are we talking about analog? And again, I apologize to people that might have heard me talk about this during the voir dire session, but the easiest one to show you is self-defense. All right. Now, self-defense is what? It is not a theory of the case, but it is a legal component. All right? So say you have a case that has a legal component in the theory of defense, of self-defense. Okay? I can't say with certainty without knowing what the actual theory is if this is going to be true, but I'm going to say there's a high percentage, probably 90% of the time, what will the dominant emotion be in self-defense?
Fear.
Fear, right? Okay. So, we are going to look at the raw emotion of fear, right? And fear is in our case, and we're going to go into people's lives with fear. We're going to ask it as an imperative, right? And that's a command. We're going to ask it as a superlative. So, how are we going to ask it?
Telling us right.
Tell me the most frightened you've ever been. Now, this is where it becomes so important. And some will have said this, during her lecture, and I agree 100% with it. What do we know about past behavior? We know that, and that's the whole basis for what we're doing here. Past behavior is the best predictor of future behavior. And why do you always file the motion? To keep out your client's prior convictions. Because you know that when the jurors hear that your guy committed a crime before, they just make about an 80% movement toward guilty, right?
Right.
And that's why if you, and I'm not asking you to go do this, but if you went and read Wigmore on evidence, he even goes so far as to say, the reason why we have to have these rules like this is because of that very thing, and because it's true. And it is true. You act more like tomorrow like you acted yesterday. Does it mean it's absolutely foolproof? No, but it's damn close, right? So, what are we doing? We're going to take that person with that question you asked. We're going to get one of their top 3 frightened situations, right? We're going to have them anchored in the reality, so when we ask them questions, the questions are coming from the past experience as opposed to asking them to hypothesize, right? Or to just give us an aspirational answer. Because we're going to always work within the story that they're telling us. Make sense? Mm-hmm. So, if part of your theory of the case in self-defense is how your client really didn't have any time to think, right?
Right.
He had to act spontaneously. He had to act reflexively. Now when you talk to these people, they're probably not going to, but this happens. I want you to understand. They're probably not going to talk about a situation where, like your client, they had to shoot somebody. But you might get one of those. It happens. You cannot believe. There used to be, you guys are probably too young to remember this, there used to be a television show, one of the early crime shows called Naked City. And it always began with, there are a million stories in the Naked City. And man, there are all these stories that support your theory in that veneer. No doubt about it. You know? So, tell me the most frightened you've ever been. Now, as they tell you the story, what do? You're asking the who, what, why, where, and when. And you're not saying anything, don't get me wrong, you're not going to say, that's just like what happened in my case. You're not going to do that, are you? That's just like, well, we're going to show you with evidence. No, we're not going to do that. But we are going to talk about it in a way that will bring out, depending on how the story is going, what part of our situation is in their story that we want to have them talk about. And what are we doing now? What if, instead of jury selection, the judge says, here's what I'm going to give you. What's your name?
Patricia.
Patricia, I'm going to give you a choice today. You can question the jurors, these people that we're going to bring in here. Or, instead of questioning them, I'm going to let you pick 10 expert witnesses. And you can have those expert witnesses come in, even before the trial starts, and stand up and talk about your case and why your case makes sense. What would you take?
The voir dire.
You take the voir dire. I think I take the 10 expert witnesses. Because, well, no, maybe you're smarter than I am. But here's what I'm saying. That's what you're doing. Do you understand that? You know when you ever been to out to Las Vegas, ever gone to a magician show at Las Vegas? You ever seen a magician anywhere when they pull somebody out of the audience? What do they say? Have we met before?
Right.
No, we've never met before. Have we talked about what we're going to do here? Of course they have, usually. But they're acting like this is a stranger from the audience. But think of this. The jury knows that you didn't bring these people in here, right? You didn't have anything to do with whose son. But these people now begin to tell these stories. And what are we doing? We are contaminating the veneer with our approach. You wanted to level the playing field. This levels the playing field like nothing you've ever seen. Yes?
Wouldn't interrupt you too much if I asked you, I have 2 self-defense cases, young
Okay.
guys. But the problem is that both young guys were doing something beforehand that is also a violation of law, even though they're not charged with it, like like going through cars, and then someone will come out from a bar and just pound them, or or just destruction of property in a
You know,
stupid way.
and the owner comes out?
Yeah, yeah, and just pounds them. So how would, in a voir dire situation, how would you deal with, it's kind of like the over-discipline or something?
Okay, will you hold that?
Mhm.
And that's, you know, we're gonna go, I'm trying to get through it all. We're gonna use specific examples, and I'll be glad to talk to us as a group about individual cases. But so don't think I'm really trying to duck it, but we ought to get through the whole thing first.
Okay.
Before we do that,
I have
yeah.
one quick question. I've had that experience where I have somebody on the jury and they kind of start espousing what you were saying about one of the most spiritual. And normally that person is
Be
preempted by the prosecutor.
Okay, this is what always happens. Everybody asks that question. Number one, I know that's gonna happen. Well, I shouldn't say that. It depends on how they tell the story. But there are certain things I'm gonna extract and make my point through that person. I'm gonna lose that person. Prosecutor is gonna do exactly that. But I don't care. The reason I don't care is, the truth is, if I'm gonna get any information about some people, when I get it, the prosecutor's not gonna like it. Just like if I get them, I'm not gonna like some of them, right? And we're gonna strike them. But the difference is, I'm using that person before the prosecutor knocks them off to contaminate in a nice way. I mean, it's not really a bad contamination. It's not anything that's illegal.
Okay.
And the other important thing is, let me give you another example, even though I'm getting ahead of myself. This is the second easiest example I can give you. Let's say you have any form of a police misconduct case. Say you got Larry Baker, right? And one of the big things you've got to deal with is the confession, right?
Right.
And in your theory, and I'm not saying this is the theory you should have for Larry Baker, but in your theory, let's say he confesses because of the trickery of the police,
Right.
okay? Now, what's a really great question to ask all of these people? Well, first of all, it's going to be an imperative, because that's the methodology, right? Tell us, share with us, and we're going to make it a superlative. Could be the best, could be the worst, but we're going to pick the worst. Share with us the worst you've ever been treated by a police officer. Now, you're going to get the full spectrum, right?
Right.
You're going to get people who talk about how the cop was just so rude. Okay, I was speeding, and I was willing to acknowledge that. But why did that police officer have to say to me, treat me like I had committed murder? You know, and so rude, so mean. I didn't say anything. I was just trying to be polite, all the way to people who have been truly harassed, right, by the police. And you might even get a story. I mean, I've seen this happen. You might get a story of somebody who sued the police and got a recovery. Well, they're gone, baby. They're gone. But boy, what have they done? And you know what? It is totally foolproof. What can the prosecutor do to challenge, in his voir dire or her voir dire, to challenge it? They always want to do this. They want to get up and say, tell me the best you've ever been treated. So who cares? I mean, who cares? Are we saying that every cop in the world is bad? No. All we want the jurors to appreciate is that all police are not necessarily good. They make mistakes. They do things that are wrong, right? Because what are you doing? You're telling a story of how the police did something wrong, how they didn't act fairly, right? And one guy in Kentucky, after I taught this, he called me up and he said, Vince, I'm doing that police misconduct question. And he said, so, you know, I'm sure you have this, but usually have the investigating officer sitting next to the prosecutor. No, you don't have that? We have that. Okay. And so the cop is sitting there, and he takes his hands, puts them up to his face, puts his head down. Like, oh my God, this is horrible, we're being destroyed. Yeah.
How do you say that they object that it's not fair with your question? What's your response?
When they object on what basis?
That it's not a fair voir dire question.
Well, Your Honor, I think it's the first thing you have to understand. I can use a peremptory challenge on any basis that is not one that is not allowed by law, such as race, religion, sex, gender. So I would think that the prosecutor, as well as I, want to know how these people feel about police officers, and what is a better way to learn that than to understand this. And you know what? Don't they always ask questions like, would you believe a police officer? They always let you ask those questions. Would you believe a police officer over another witness? What are we trying to do? We're trying to figure out how they feel about police officers. I want to know how they feel about police officers based on their experience. Your Honor, how could that be? How could that be anything but totally permissible? And as you can see, I'm not trying to get them to prejudge the case. I mean, I wouldn't say that unless they try to say that to you, because you are. But the thing is, it's not like, I haven't told them anything about the case. I'm asking about their own experiences. Yeah.
The objection that I've gotten from judges on the same methodology that I've done back in my state is that it doesn't go to the qualifications of a juror. And therefore, if it's not a question that goes to the qualifications of the juror, it's not permitted in voir dire. Qualifications being that they're not related to anybody here, that they have no physical infirmity that prevents them from serving, etc. But it doesn't go to the qualifications.
Well, it goes to the basic. Do you have peremptory challenges?
Yes.
Well, in the law in your state, just like the law in everybody else, that you can use a peremptory challenge for any reason? Okay, so that goes to a qualification that goes to what I have a right to find out information that I can base my peremptory challenge on. And if I can sit here and judge on the basis of the tie the guy's wearing, if I can judge it on the basis of the neighborhood, all of those things are perfectly permissible. I want to know about these people's experiences with police officers to exercise my peremptory challenge. Judge, you're talking about whether or not it goes to a challenge for cause qualification. You're not talking about peremptory. And you've already let the prosecutor, because I usually don't get to go first, you've already let the prosecutor ask, and in fact, Judge, you ask questions that didn't go to their qualifications. You ask questions that go to a peremptory challenge, you know?
Okay.
Yeah.
In our jurisdiction, supposedly, we're not supposed to be asking questions for peremptories, but cause is where you have to ask, you're allowed to ask questions about. And if someone is biased, comes into the courtroom biased because of the race of your client, gender of your client, they hate police officers because they got beat up and it's a police misconduct case, that goes to bias.
Yeah.
So I think the response to your judge is, Judge, this goes to a challenge for cause on the basis of bias. We need to find this out. That's why the question is proper. It's a cause thing.
And you know what? If you've already, and you say, I'm sure, I agree 100%. I would do both still, though. But in your jurisdiction, you can't do that.
I can't say I need
Right.
the information for peremptory.
Right.
Right.
But the other thing is, Your Honor, if someone has been so biased by their encounter with a police officer, I'm sure that the prosecutor, and they would say, well, let the prosecutor ask that question. We'll say, well, I need to know too.
You want to know, Judge.
Yeah,
You don't want a bunch of biased jurors in here.
Fine.
The question is more basic, which is you start and you get that perfect response from that first juror, let's say, and you explore it, and they are contaminating the jury.
Mhm.
Now, you get what you want out of that person. You move to the left and say, now you tell me, do you go person by person through all 50?
I tried to, of course. Well, probably not all 50. I'm going to do a bunch of them.
Okay,
I'm going to do a bunch of them.
okay.
Starting with 1-1, starting right at the beginning?
I'm sorry.
Oh, 1-1 is the first
First one.
First
No, I
one.
jump around. I do stuff like, I don't usually try to get them to raise their hands. I try to get, and there's all different techniques for keeping them talking. But I might look at somebody and say, you look at the expression on your face, am I reading it right? My judges will, in Kentucky, most judges will let me do that. Am I reading it right? Did you have an experience like that? Do you have an experience with a police officer? See what I mean? And, but if you're dealing with a panel that's so big, you're not going to ask everyone that. But you can at some point say, are there some other experiences you've had with police officers that you think you need to share with us? See?
How, and can you define big? You said your panel was so
Well,
big.
you just said how many you were dealing with, 50?
40, 50.
Well, yeah, well, then if you question all of them at the same time, is that right? Are they waiting over there and they're gonna call them back up and say,
They bring in, let's say, 40 at once.
so you're talking to 40 people?
40 people at once.
Well, what I'm saying is, depends on how it's going, I would move it around, but you might want to, as a wrap-up, say, now you've heard a number of the jurors, potential jurors talk about this situation. Do some of you have some stories you think we really need, some situations where you've been treated badly by a police officer, you think we really need to hear this to be able to decide whether or not you're a good juror? And then that's a way to get, some people say, "Nah, it's not that important." Other people might say, "Oh yeah, let me tell you," so you don't miss that. See what I mean?
Sure.
And it is true, you raise a really valid point. That big of a group, I'm not going to be able to judge every person on the basis of answering that question. But I got to get some information from everybody as best I can, right? But what I'm telling you is, voir dire is imperfect in that situation to be able to truly evaluate those people. So what do we want to do? We want to get the most out of it to move our theory of the case, and that's the contamination that we're doing. Yeah.
I got one quick question. I was, in my state, I was one of the first when Baston versus Kentucky came out.
Mm-hmm.
I was one of the first attorneys, myself and my partner, we used that and we had an armed
Right.
robbery case. And we got the judge to use the Baston challenge. But now, since it came out, it's almost like a book I read by Levy, I think, that says that first you start with a theory, and then after a while it becomes absolute. You have these categories, and then everything becomes inclusive.
Right.
And then it's no longer any good. I think, I can't remember, I know a guy named Levy that wrote a book of legal something. But anyway, how can I still use it these days? It's come to the point, if somebody say, well, I didn't like the look on his face, and I exclude him. You get a prosecutor exclude minority jurors, be they Hispanic.
You know what, Arthur, I'm not going to answer that question because that really is more about Batson and how to handle that than it is about
Okay.
this kind of voir dire.
Oh, okay.
And you send me an email,
Okay, okay,
because I'm going to be leaving at the end of today.
okay,
But you send me an email
Okay.
and put it out for me and I'll deal with it.
okay.
But that's going to take us way
Right,
away
yeah,
from
yeah,
what I'm
yeah,
trying to do, okay?
Okay, I'll reserve it.
Okay. So where were we? We're on still on the most perfect analogy.
Right, yeah, okay.
Okay. Let me give you another example. If you noticed, the first one was fear, and it was the dominant emotion, right?
Right,
When we looked at the worst a police officer has, if you've ever been treated by a police officer, we were really getting to the facts, and a big part of the issue that comes out of your facts, right? So, how about this one? This one, and I used this in one of the sessions. This was not my case. I consulted people. This person called me and said they had an entrapment case. And in this entrapment case, this woman said, "My husband's a lawyer. I've never heard you speak." This was somebody in Kentucky who said, "My husband told me about this voir dire, and I got a trial coming up on Monday." This was a Friday, late in the afternoon, when people always call you. "I need it tomorrow," right? So, what kind of questions should I ask under your method? It's an entrapment case. So what did I say? I can't answer that. I don't know enough about your case, right? What's your theory? So without going, I didn't go through all this stuff like I did with you about what a theory is, but she basically, when she's telling me the facts and that, we get to the point that the guy was entrapped by his brother-in-law. Okay? So what's the question? What's the question? Tell us the superlative. What?
Worst experience you had with a family member?
Okay, that would, now, see, this is really good. Tell us the worst experience you ever had with a family member. That's an analogy, but it's not the most perfect analogy, right?
Tell us the most pressure you've had by a family member.
Okay, that's a good one, and maybe it's better than that one. Maybe they're the same. Gotta get closer.
Tell us the worst betrayal you've had.
Tell us the worst betrayal. We're starting to get there, but the problem with worst betrayal is that choice of language going to also indicate that, you know what? Sure, if I come to you as an agent of the government, you're my brother-in-law, right? And I try to get you to buy drugs, or I know that you want to buy drugs and I'm there to help the police, I've already betrayed you. So that one The more we get
Trust.
What?
Like, what's the worst mistake you made trusting a family member?
What's the, all right, that's a good one. But here's the one I came up with, and I think it comes the closest. Tell us the most significant time when you did something you really didn't want to do, only because a relative asked you to. Now, why is that better than the ones you all gave? Because what is the definition of entrapment? You had no desire, you had no interest in doing the thing that was criminal. That interest was created by the person that entrapped you, right? See how we're trying to get it closer? And she said, she called me back, because she got an acquittal, she called me back, of course. She said that when she did this, all these family members, I mean, not these family members, all these veneer people told story after story about things that they just were, as you all said, somebody said, pressured into, right? By the fact, things they didn't want to do, like vacations. They were like, we've never gone to this place. And we tried to tell them. And they insisted, we went. And then, you know, your follow-up question in that situation, as I told them to do, is, and how did it turn out? And most of the time, it won't be universal. In that situation, she said, it turned out, it was horrible. Just like they thought it was going to be. Just like your client. Oh, I shouldn't do this, I shouldn't do this. I got to do it for my brother-in-law. I do it, and now I'm facing a criminal prosecution. Right? Do you see how it works? See how it moves your theory of the case? And you're finding that analog. Right? Now, let me give you an example of what, I'm sorry.
And Vince, is the analog coming from, in entrapment, it's coming from knowing what the law of entrapment is.
Right.
In self-defense, it's knowing.
But it's all,
what the-
yeah, you had, in that one though, you had to know two things. You had to know it's coming from what the law is for entrapment as a defense, but also it's coming from the facts, that it was a brother-in-law,
Right.
and that's why you went to a relative instead of somebody close to you.
Okay.
I mean, what if it was a business associate? You wouldn't have used relative, but you might have, and that's what we'll talk about in a minute. Sometimes you expand the analogy if you think you need it to get more answers, okay? But you're right, it certainly came from the law. Is this what you want to hear? Are we on track, okay? All right. Now, let me give you the, I think this is the best example, and it's in my handout, for when the analogy is, what do I call it? I didn't think, I didn't really prep. Let's see. An imperfect, that's what I'm looking for, an imperfect analogy or analog. Okay, mistaken, again, not a theory of the case, but in your theory of the case is there's a mistaken eyewitness identification. So, have you heard, or have you ever done as part of voir dire in a bad ID case, have you ever asked the question, a lot of lawyers do it, I've seen guys get up and lecture on it, women lecture on it, you know, at these programs. Have you ever been walking down the street, in the mall, and across the street, in the mall, you see, oh, it's my old friend Joe Dokes, right? And you walk over, and you tap them on the shoulder, and they turn around, and it's not Joe Dokes. And you're so embarrassed, you say, I'm sorry, I thought you were somebody else, right? Now, what's wrong with that? Why isn't that a good voir dire question? Why isn't that a good analogy? Because it really bears no resemblance to what is happening in your case. If that had happened, if in your case, the the person who was robbed had seen your client in the lineup and said, oh, I thought it was you, but it's clearly not you, then they wouldn't be calling her as a witness, right? Okay, so what are we really looking for? What is, and see this one's good, I think, when we try to come up with the more perfect or most perfect analog. You got to really look carefully at what an eyewitness identification is. Anybody want to try? Anybody got any ideas what the analog might be? You don't have to, I mean, but if anybody wants to try it, welcome.
Okay, what about what they gave us the other day? I heard one in talking about eyewitness identification. Somebody gave one example in one of the lectures, didn't they, where they saw somebody walking across the street or something.
Well, that's what I just did.
Yeah, okay.
I said, that's terrible.
Okay.
Sorry. Okay. Here's what I want you to think. Think about this. Tell us the most significant time when you or someone close to you, family member or friend, believed mistakenly in something and persisted, man, I want to use persistent with a dream, but I was that continued in that belief for a long period of time, only to find out they were absolutely wrong. You know what kind of situations, have you had situations like that? You know, the reason, if you notice, I expanded the question to include more than just the person, because spouses like to tell the story of their significant other. And, you know, a perfect example is, think about it for a minute, perfect example is people my age saying for years to people, I know exactly where I was when John F. Kennedy was assassinated.
Right.
And they've been telling people, and one day they're saying it in a family gathering, and their mother or their brother says, well, that's not true. We were at such and such. And the person starts arguing, and then they say, oh my God, for all these years I thought that's where I was, right? Isn't that what you're saying is happening in a mistaken identification? And what is happening then is when you get into the details of those stories, right? Then you're having people, you want to emphasize things like, but you were so sure that's what happened, right? I mean, how long did you think that? 10 years? And you told people that story? You were so certain, because what are you going to do? You're probably not going to break the witness on cross-examination, right? But what the people are saying is, what you're saying is, hey, just because somebody is so convinced they're right, just because they persist and continue in a belief, doesn't mean it's right. And so you got all these people, not under oath. Well, they're under oath because they were sworn in as veneer people. They're testifying under oath. This happens all the time, right? See how it moves your theory?
I
You got your arms folded. Does that mean you're in trouble? Okay.
I got it. I would do it differently. I've had a situation where people continuously walked up to me and thought I was somebody else. Like,
Well, you're missing the point, Arthur.
Okay.
You're missing the point because that isn't happening in this trial.
oh, okay.
Okay? If that happened in this trial, the prosecution wouldn't be calling that witness, because that witness would have looked at your client and said, you're not the person that robbed me. That's why that's an imperfect analogy. And that's why people have been teaching that, and it's wrong. It just doesn't move your theory of the case.
Oh, okay.
That's what we're talking about.
Okay. I got it.
See, it does require you to think about it.
Okay.
And it requires you to say, what is that the most like, right? Some of them are really easy, right? Fear in the self-protection, in the self-defense, self-protection was not that hard to come up with, right? But some of them require a little bit more thinking. And what I'm doing this for is to say to you, if we'd taken your first one a while ago, or the other ones that were thrown out there, they might have worked really well. But what you're always trying to do is trying to make it better. Someday I'm going to think of, or you're going to think of, and you send me an email and say, I like your persistent belief, but I got one better than that, a better analogy. That's why I don't call it the perfect analog, right? We're always looking to get the one that is the most perfect, the closest we can get to it. Does that help? Okay, now you noticed it's a judgment call you're going to have to make. And that is how wide to make the net. You make the net intensely personal when you ask it, tell me the most frightened you've ever been, right? So that is asking them to tell you something that happened directly to them that they experienced. But that's not always the best way to do it. So you have to decide, do I want to expand the net? And if you want to expand the net, you got to be really careful. Somebody, when we were doing voir dire, tried to do this, and they said something like, how was it? Tell me about a situation where someone was frightened. Okay, now what you've done is you've opened it up that somebody can tell you about a movie they saw. They can tell you about a TV show. They can tell you about a book they read. That's not going to help you, right? So, but the other thing is, you want to expand it sometimes, because some of the questions, you just have to try to figure it out for yourself what you think. Some of the questions that people may be better able to tell you based on their experience with other people. Maybe a mother of a child who's now even an adult, when you ask the question, is going to be in a great position to talk about the experience her child went through, right? And that she was privy to everything about it. And that may help you too. So that's when you do it. So you can probably, here's where I am on the expansion. It's a little cumbersome, and you may be able to figure out a better way to do it than I have so far. Notice how I said, tell me the most frightened you or someone close to you. And now try to help them by saying a family member or a friend. But you kind of throw in there. You don't want to make it too big. You have a co-worker. I'm hoping co-worker, if they know well enough, they would consider a friend. But see, a family member or friend to make it wider. Yes, sir.
It's because the eyewitness one, to believe something fervently and be wrong is kind of pejorative. You fuck up. By expanding it so that it's not personal,
It makes it
it
easier.
makes it easier to tell the story.
Yes.
Whereas fear, personal. Worst experience with a police officer, that can be personal,
Right.
and it doesn't have to be.
You're getting it. You're getting it.
Okay.
Exactly.
Okay.
And sometimes what will happen, I think, based on my experience with it, is sometimes when you expand in that, a person may tell you a really personal thing, as if it happened to someone else when it's really happened.
Right.
Okay.
And actually, that's something that I was going to ask about.
Go ahead.
Because, if you're asking when the time you were most frightened, and, there might be a situation where someone knows exactly the time where they were most frightened,
Right.
but it's not something they want to share with the rest of the jury veneer, with the judge, and with the court reporter writing it all down.
Exactly.
And so I guess would it be if they don't want to share, would you expand the net? If they say, well, I don't want to talk about it, or if they just shut down?
Well,
how would you deal
here's
with
one of the things you haven't given them permission in the question to do this,
Mhm.
but as I understand it from the psychological studies and behavioral description interviewing, because you ask them for the most, the worst they've ever been, the most frightened they've ever been, they may do the selective of dropping down from the worst, or the most frightened, to the next most frightened.
Mhm.
Some people may say to you, I have an experience like that, but I don't want to share it with everybody. I mean, I've had people do things like that even in the other kind of voir dire, right? And that's the question that you might want, then you want to say, Your Honor, could they approach the bench, or could we speak to them outside the presence of the rest of the jury, The judges might not let you do it. Might say, you shouldn't have gotten into this in the first place, but anyway. But I think more likely than not, they're going to self-censor a little bit and probably drop down to the next one if they really don't want to talk about it. Although I've had some incredible things. I had a woman, I was trying to do it with regard to, tell me the most significant time when someone thought that you had done something that you didn't do. So a bunch of people answered. It's well, yeah, we're going to get to it, but you can write it down. It's a good one, isn't it? And so this woman, she said, excuse me, sort of thing, I want to talk. This really isn't exactly what you asked, but I was raped once. I was raped once, and the police brought back to me the man that they said they thought raped me. And I told them, that is absolutely not the man. And they said, you're wrong. That's the man. And I'm like, thank you! And you got to be flexible. You can't say, it's not exactly what I want. And so she told the whole story about how they actually tried to take it to trial. And until she finally convinced them, I'm not going to go in and say that because that's not the guy. So see how wonderful it can be? And so sometimes it triggers something. And I always say this when I talk about cross-examination. It's the same thing with jury selection. If you know your theory of the case so well, if you've done it what we've talked about in the beginning, you have the ability to be flexible. The spirit is flex. So when you get, and this happens a lot with this technique, you might have 5 things prioritized. And this question doesn't seem, that you're using for the first thing, doesn't seem related at all to number 5. Or maybe even farther down the list if they gave you all the time you really would like that. But you get a situation that not only fits what you asked for, but maybe fits even better something down there. That's the time to go ahead and try to make that point too. You with me? Or come back to it, yeah.
Yeah, we had a really interesting situation just during the mock flood year. Somebody in Kitchen's case had a juror who talked about how she's been a battered woman and actually shot her husband and he didn't die. You know, my natural inclination would have been to exploit that to get all the information I could about battered woman syndrome from that lady and, you know, what happened with the husband and what happened to her and all that. And then, you know, there were really good points made that that's such a sensitive situation. My duty is to my client, I believe, not to that lady. But then I was thinking, am I going to look like a complete asshole or jerk exploiting that kind of situation in front of the jury and turn the jury off?
No, because you do it in a, I mean, this is more, that's a great question, but the way you do it is you do it in a tender, caring way. And you even say, I know this is probably difficult for you, but it's very important. And see, I mean, if they try to challenge you on this is perfect, because this person's been through a similar crime. You're gonna lose this person, right? But if they try to say, she's gone already, say, oh no. You couldn't just challenge her for cause on the basis of that. You gotta know more about it, and that's what we wanna hear more about it. Say, and so you can say that. This is so very important in this case to determine whether or not you're the right juror here, to ask you some more questions about it. And if you notice, the whole approach we're doing here is we're never going to go back and talk about our case. We're not going to say, look at the great parallels. We're making the parallels, so it's not like we're exploiting her. You see what I mean? We're talking to her about a situation she went through. Now, that's another thing I haven't said. Sorry, I just took a break sitting down. But what we're doing, really, is when we're talking about this, we want to make the people feel comfortable, and when they're inside this story, we can trust it so much more, right? And so the other thing, I lost my point for that. Anyway, what I really want to say is what happens here is the power of this kind of voir dire and the ability to get more time comes from the fact you are really not talking. The jurors are really talking. And you know what? They enjoy it. They're talking about, they're not being tested. They're not being asked, what would you do if the client didn't testify? Would you be a scumbag and hold it against them? What kind of person are you? Are you an American or not, right? But you're asking them to tell about their story, the stories of their life. I mean, you know, you get, I don't know, did you go out to dinner last night? Did you sit with people? Did you have some conversations where you talked about things that happened to you in your past? That's what we like to do, right? So here's the other thing. I don't know about your state. My state, the judges are elected. These are the, and when I'm out in the States running cases, or if I'm in Louisville where we got 16 felony court judges that handle criminal cases, it doesn't matter. These are the people that vote for them, right? And it's not boring. That's another really important thing. It's interesting because it's not the same thing the judge hears over and over again. Even if you go in front of the same judge every day, the voir dire is always different. The structure is the same, the method is the same, but because every case is different, the stories are going to be different, right? And the juries are different. So that's what, it helps it really make it work very well. I finished voir dire in a case, judge I'd never tried a case in front of, and we're walking out to the break, and the judge comes up to me, and we're going to meet in chambers with the prosecutor, and he says to me, so as we were walking out, my clerk said, why have I never seen anybody else do voir dire like Mr. April did? And the judge says, I don't know. What do you think? He said, well, I think all of them should do it like that. And the judge said, I told him, I do too. You know? It makes it, I know you don't believe it, but think how bad it must be for a judge in voir dire to hear people get up, the prosecutor and the defense attorney, asking the same kind of questions over and over again about, can you trust a police officer, reasonable doubt, all this kind of stuff. This is so different. And so there's a lot of good reasons why it works. Okay. Wow, we're moving along here, aren't we? Let's see what maybe we should go to next. Here it is. covered the imperfect analog, the more perfect analog. We talked about the net. Okay.
Did you talk about the net?
Now, just talk about the net, expanding and opening.
Expanding that, yeah.
Tell us, you know, when you say, when you're talking about you, tell us the most significant, tell us the most frightened you've ever been, or tell us the most frightened you or someone close to you, a family member or friend. You're expanding the net.
Okay.
Okay? I had my, anybody here ever had a Myers-Briggs test?
Yeah, the what?
Myers-Briggs psychological test? Yeah? Well, you know what I found about me, and I think they had it exactly right. My personality, one of the things is, I do A, I tell people A, I tell them C, and I assume they understand B. So I may have done that to him just a minute ago, okay? I have to always kind of watch the people. I think it was exactly right for me. All right. You were interested in a question that you were going to write down, and I said we'd get back to. What was that question? Do you remember what we talked about?
Is those a situation where you've been accused of something that you didn't do or something?
Okay. Did you notice how we were doing that? I try to get away from...
Excuse me, I couldn't hear a question.
Oh, the question was, you were asking somebody to tell you about an experience they've had where they were, and I'm going to use the wrong words here, accused of something they didn't do, okay? And why are we doing that? Because we're talking about, in our theory of the case, false accusation is going to be really important. Now, you could do that in every case, but if it's not really truly a part of your theory, you don't want to do it, right?
Right.
I don't think, because then it's just a generic question that applies to anybody. But there are certain cases where that's really important, right? So, what I try to do in that situation is to find words that do not convey necessarily, to formulate it in a way that does not necessarily indicate the criminal justice system. I'm really trying to stay away from that. So, tell us the most significant time when someone thought, now see, I could say accused you, I could say allegation, I could even, and I have in the past said suspected, but when someone thought you did something that you really didn't do. Now, I've left that pretty wide open, and I'm not necessarily saying, have you ever been falsely accused, right? See the difference? No?
Yeah.
Okay.
Because you're not asking them something that's a foregone legal conclusion.
You might get somebody who will tell you a story about how they were falsely accused, like that woman, or even a permutation that I told you where she wanted to talk about how she was in, someone said, wanted to falsely accuse someone of raping her, right? So, you see how it works on that particular question? And it's nebulous, but it's intentionally nebulous. And you know, don't be afraid when somebody starts telling you something that seems pretty minor that happened that they were up, because you're going to talk to them about what it feels like when you know you didn't do something and somebody believes that you did it and they're wrong about it, how you handled it, how you were able to, what, did you feel powerless, you know? How could you do, you see what I'm saying? All right, another example. What if your client, your theory is your client lied on the way, lied when he confessed? Well, you got to figure out in your theory, why would he lie, right? So, let's say, I mean, we could talk about Larry Baker, but let's say in your theory, it doesn't have to be Larry Baker, your client was so desperate for some reason connected with the case. I'll give you one. Hold on a second. Gives me a chance to read that theory. This is a fun one. Faced with having accidentally erased the convenience store videotape of the cashier's murder, the only evidence of the murderer's identity, Officer Jones, desperate to correct his mistake by solving the case, forced a false confession from Bill Smith, who was only remotely associated with the incident, by lying to Bill Smith about the evidence against him and threatening to prosecute Smith's sister and to take her children from her. Even though the only witness to see the murderer fleeing from the scene has repeatedly stated that Bill Smith was not the fleeing murderer, the police and the prosecutor, desperate for a conviction in this bungled murder case, continue to prosecute Bill Smith an innocent man solely on the basis of an unreliable, I can't find the rest of it, an unreliable confession obtained by lies and threats, right? Okay.
That's why you
So-
want it on one page.
Huh?
That's why you want it on one page, right?
Well, I have two on
Oh.
that. Yeah, but you're right, you want it on one page, so you don't lose it. Okay, so if you thought Larry Baker or Bill Smith here, if you're saying the dominant emotion that moved him was desperation, right? He was in a desperate situation, didn't know what to do. What's your question going to be to move that theory of the case? Tell us the most, and you may not like this formulation, I haven't been able to come up with anything better. Notice I say a lot, the most significant time. And if you feel uncomfortable with that, you're looking for something, you know, and the best I could ever come up with was significant. You may be able to do better than that. But tell us the most significant time when you lied out of desperation. Or when you were so desperate, tell us the most significant time when you were so desperate, you felt that you had to lie. And I had a guy in that situation, you know, you talk about, oh, he's gone now right now. Not that there's anything wrong with that, he's coming back. But when he talked about, I think he was the one talking about how personal it could be for a person. This guy said, I really don't want to talk about this, but I think I know what you're talking about. He said, a long time ago, when my kids were young, I was unemployed, couldn't get a job. Times were tough, we were running out of money to live on. He said, I went in, job application. I lied, I just outright lied. I just had to get that job. I didn't know what else to do to save my family. And so what am I saying? You know, desperate. Yeah, I was desperate. And why did you know it was wrong? Of course I knew it was wrong. Did you know you were lying? Yeah, I know I was lying. Or, you see what I'm saying? You get into that story, but you did it. Why'd you do it? Because I didn't know what else to do. Poor old Larry Baker, right? Poor old Bill Smith. They were put in these desperate situations. And people do desperate things, you know? And you don't have to, and if you wanted to say, well, maybe I don't, even though it's lying, you know, maybe I want to make it, not exactly the net who's answering bigger, but you may decide, how about if I say, tell me the worst thing you ever did out of desperation. Or tell me a time, tell me the most significant time when you did something you thought you would never do because you were in such a desperate situation, right? See what I mean? What we're trying to do, trying to get into that. But you can't come up with a question if you haven't figured out your theory, right? So, you want to talk about some other situations? Let's see. Boy, I'm missing. In the handout, I've got a whole bunch of them. A lot of them, in the handout, I have that Joey Burton theory of the case, and I started off using some that fit under that case, and then I just go on and move into other things. But there's a whole bunch that you can get from of examples. Let me jump ahead. See. How about this? The prosecution has against you an expert witness, okay? And you don't have an expert, and you're going to try to show that their expert is worthless, right? One of the things you might want to do is this. Tell us the most significant time that you or someone you know well changed doctors